courts have no jurisdiction over the internal affairs of a political party except where a statute expressly gives a court jurisdiction to deal with any internal affair of a political party. Now, it cannot be any more clearer than this, because for all those who are agitating about 183 and all those other things, the court have said, and actually this decision is in line with a series of other decisions of the court, which I didn't want to go into here. So by and large, these are the decisions of the court on those two issues. Now, I'll just mention briefly something, as I said earlier on, the court touched on so many things which are extremely important for the administration of the activities of all parties and officers who will sign documents and all that. Now, what the court said is that officers are not the sponsors of political parties. It is parties, candidates are determined by the various congresses of the parties at the local government, state, and the national convention. Officers do only convey the decision of the party, concluded at those levels. And it means any officer can be mandated to do that. It doesn't have to be chairman or national secretary of the party. Before now, that wasn't the understanding. So a lot of senior officers were put under stress. The court now have clarified this, and also clarified the issue of the status of the guideline of INEC. That guideline cannot provide anything that is contrary to what is provided in the Electoral Act, as well as the Constitution of the Federal Republic of Nigeria. So these are very important decisions, and quite a number of others. I believe all those in charge of party administration should read the judgment of the Supreme Court on this, because there's a lot of guidance there. And therefore, once the party submits the names or list of candidates, INEC cannot disqualify anybody on any ground. The law is very clear on it anyway. Finally, in the light of these clarifications, we call on all APC members who have sued the party to withdraw their cases and use the mechanism of reconciliation to address their grievances. Their initial euphoria from all what we've been hearing, that the minority judgment have opened up a window for them to go and challenge decisions, is not correct. The correct law is that they are shut out. So it is better they explore internal mechanisms within the party to address their grievances. And finally, we also advise members to focus on all upcoming congresses, ensure unity and harmony in the party. The dying PDP on its part should focus on the logs in its eyes and leave the APC alone, to make it as simple as possible, because the language of the law can be intimidating and sometimes confusing, especially to journalists, right? Now, until now, the CECPC avoided making statements or pronouncements on the raging controversy with regards to the legality of the CEPC and that of its chairman. It left the matter to be attended to by the leaders and stakeholders of the party, because we are interested candidates. and loyal servants of the party. Secondly, another major reason was that until now, the full judgment of the Supreme Court was not available. What has been in the press are summaries here and there. Now, as a law teacher, we always caution students against relying on summaries because a lot of times the meat of the decision is left out. Now, there is always potential danger in commenting on incomplete picture when relying on newspaper reports of a case. This precaution is now confirmed upon due reading of the full judgment of the Supreme Court of Nigeria. A release was made yesterday on this. This press conference will therefore only briefly concentrate on two issues, as many other issues were considered and decided by the Supreme Court. Other relevant issues, if any, could be taken through questions from the press. Now, the two issues are, if the CECPC is illegal. Secondly, if the position of the chairman of CECPC, His Excellency Maimala Buni, in holding dual office as governor and chairman is illegal. On both issues, we state the position and decision of the Supreme Court only. The decision here is the majority judgment of the Supreme Court, which is now the law. The decision and judgment was read and concurred to by the justices who were in the majority. Any other statements in their various additional contributions by the justices complement the lead judgment. I say this because I've had a lot of statements by commentators saying the majority of the justices didn't say this or didn't say that. Now, this is because they don't know the procedure of the Supreme Court and the Court of Appeal when they are working in panels. The lead judgments are usually circulated and discussed by them, to which once they concur, it becomes their judgment. Now, there's a requirement of law that they have to write judgments in writing. Some would simply say, well, I have read what my learned brother said. I have nothing else to add. I concur. That's his judgment. Now, what his learned brother, the lead judgment, now reads becomes his judgment completely. Another person will adopt what the lead judgment writer, justice, has written, but also go on to add, to expatiate on areas he's interested in. And even in this present judgment, this is what has happened. You find some of the judges who agreed with the lead judgment also went ahead to discuss some other issues which are not covered there, or which are actually covered there, but also amplified on it. But overall, there's no disagreement on everything in the lead judgment. So that's why it becomes a majority judgment. Now, it is therefore right to say that the issues and ratio in the lead judgment reflect the views of majority, as I just explained. The minority judgment, although important as it is not the judgment of the court. A lot of times, minority judgments get very attractive, especially to lawyers, students, teachers. You know, they go into a lot of certain details. But that's what it is. It remains a minority judgment. It's not a majority judgment of the court. And it's not a judgment of the court. So I take them one by one. As I said, in very short. The Nigeria Supreme Court, in its judgment, affirmed the legality of the caretaker's extraordinary convention planning committee. This court stated that the NEC, National Executive Committee of the APC, under Article 13.3.4 of the APC Constitution, has power to create, elect and appoint a committee and endow it with powers and functions. It even went ahead to draw a parallel with Article 33 sub 3 of PDP Constitution 2012, which gave similar powers to its national convention, which in turn appointed a national caretaker committee in 2016, which the Supreme Court ruled to be legal. This case is Sheriff versus PDP. Secondly, on the status of the acting national chairman, His Excellency Manuel Abuni, the Supreme Court held that he was appointed only in acting capacity on temporary basis to carry out and fill in the seat of the national chairman, pending the election of new officers. The Apex Court held that Manuel Buni's position as acting chairman of the Caretaker and Extraordinary Convention Planning Committee is not contrary to the provision of Section 183 of the Constitution of the Republic of Nigeria, because the appointment is ad hoc, it's on a temporary basis, which is not akin to executive office or paid employment as envisaged by 183 of the Constitution. In any case, the court further stated very clearly, very categorically, it rules that the second respondent, a registered, which is APC, a registered political party, being a voluntary organization, the question of who should hold offices in it, whether it can appoint its members to hold office in acting capacity or authorize a member to exercise the powers of an office, and whether it has violated its own constitution by appointing a member to hold a particular office in it or discharge the functions of that office, cannot be entertained by any court. This is very important, that those questions deal with the internal administration of the affairs of the political party. Those are not justiciable questions. When the court says they are not justiciable, it means you cannot go to court and ask for relief because they are internal affairs.